Thank you, Mr. Speaker. And it's actually with great disappointment that I have to stand and speak against this bill because, of course, this is work that started under the previous Labor government. And I'd say to the member who just took his seat, who said that we've learned from the experience of the leaky building saga. With the greatest of respect, I don't think the National Party has. And that's one of the core reasons that Labor is opposing this piece of legislation. Is because that those who don't learn from history are doomed to repeat it. And once again, we see this kind of ideological knee-jerk reaction to regulating in this area, which actually led us into this territory in the first place. Now, I want to make some general comments first, which is this pattern which is emerging under this national government, which is to push as much as possible into regulation, which means that when we're passing primary legislation, we can't really ascertain the full impact of that because it's going to be in the regs. And that's where the rubber hits the road. So it's become common practice under this national government. I spent the last 3 years on the Regulations Review Select Committee. We saw it time and time again, particularly in areas where there was any controversy. Everything was pushed to regulation because it meant you didn't have to get votes for it in the House. It meant it didn't go through a select committee process. It means it doesn't come into this House to be debated and be amended. The only protection is the Regulations Review Committee. But even the Regulations Review Committee, as important and as wonderful as it is limited in its ability to change regs. They can review regulations in terms of process. They can hear from people who are unhappy about certain regs, and they can hear about people who think they're unfair, but they're limited in their powers to change it, which is something we saw on many issues, like folic acid, for example. But it seems to be the more controversial the issue, the more and more it's done in regulation rather than primary legislation. That is a bad precedent that's being set in this Parliament. It's not good parliamentary practice, and it's something that should be reversed. And here we see it again, with an issue that is undoubtedly controversial, which is the Building Amendment Act bill, which is trying to address some of the structural issues that led to the leaky building crisis, and again, everything being pushed into regs. The second pattern we're seeing emerging, and I saw this again today when I sat on Select Committee, is also limiting people's ability to challenge decisions. Limiting people's ability to question and to challenge when something has gone wrong. And I want to come back to issues of liability in this legislation later on, but that's certainly another thing that we're seeing, which is when you move towards putting the onus on the builders themselves and on the consumers and away from the building consenters, you're removing an entire level of appeal and those processes that are available to consumers and to those that have been affected. And again, we're seeing this more and more often. We're seeing it in the exclusive economic zone legislation right now, which is removing appeals to the Environment Court and heading them straight to the High Court, and only on points of law, not on points of substance. I subbed in on the House Select Committee this morning when we were talking about the Natural Health Remedies Bill. Again, only allowed to go to the High Court on points of law, not substance. Again, all the guts of it in regulation, as with the EEZ legislation, as with this legislation, as with the food bill. This pattern is emerging, which is actually reducing the power of this Parliament to pass good legislation, reducing the power of this Parliament to stop bad legislation, and shifting it all into regulations which can be changed by a government with very little notification, just be gazetted, no public input, and unless someone happens to catch it and speak up on it, then it's shonky lawmaking. Shonky lawmaking, Mr. Williamson. He called it shonky law? Maybe. Oh, shock and awe. Shock and awe. Well, I don't know that. I don't know I'd go that far as to call it shock and awe. But it's bad. It's bad parliamentary process. And the third pattern we're seeing emerging is this constant reliance on future legislation. Now, again, this is like shifting everything into regulations. If you're constantly saying, well, trust us, because the next piece of legislation is going to fix it, that's not good lawmaking process. And what Labor members throughout this entire debate have been saying is, why are we doing it in such a piecemeal fashion? This is too important for us to get it wrong. Work is ongoing at the moment on other areas around liability. The Law Commission is doing some work. Let's slow this down. Let's get some idea about what the draft regulations are going to look like. Let's get some idea about what the next Building Amendment Bill is going to look like. And let's make sure that we have all the ducks lined up so that we don't end up in the same situation we were before. Because you often hear when people talk about what went wrong with the leaky buildings issue, It was that Swiss cheese approach. There were just enough holes that lined up that homeowners fell through that gap. And it wasn't that any one particular piece of legislation was to blame for what happened. It was that there were enough holes that unfortunately, when they lined up, it was consumers who fell through the gap. And we're in danger of that happening again. If we continue to pass law in this fashion, when we don't know what the regs are going to do, when we don't know what the future legislation we've been told to rely on is going to do, and when once again we're restricting people's access to appeals. And the issue of liability is incredibly important. If you look at the case of Pepperwood Mews in Auckland and the fight that they have ongoing about the role that the Waitakere City Council played when they issued the Code of Compliance for Pepperwood Mews. This is why it's so important to get it right, because this shift away from saying that councils are going to have less liability makes it even more uncertain. Well, no one knows. I mean, this is the problem. We haven't addressed the issues of liability. It is no clearer now than it was under the previous regime, and the Minister might not like it, but if he or the Minister of Housing had bothered to spend some time with those people to talk through from their point of view what happened, that when someone from council says to them, this is code compliant, we sign off on it. When as a consumer you don't have that level. You don't have that level of knowledge to be able to know that they're right or wrong. You just hope that your elected officials and the people that are paid by ratepayers' money to make those decisions and provide the advice are doing so in a proper fashion. And then it all goes pear-shaped, and then they come back and say, well, surely the council had a role to play in this, because they're the ones who said it was all okay. They also said surely Housing New Zealand had a role to play in this, because they're the ones who were promoting this as a really good investment, because they were going to tenant it for 10 or 15 years, so there was going to be this guaranteed income. And then Housing New Zealand bailed the minute it all went pear-shaped. They got out as quickly as they could. The Pepperwood Mews residents, these are 32 mum and dad investors, we love talking about mum and dad investors, who lost just about everything they had in this investment, who say that they were not even told about problems with the building before the unit titles were signed off. And had they been told, then they may have reconsidered their decision. Now, issues of liability go to the very heart of when things go wrong, so it's important that we get them right and not do it in the piecemeal fashion that we've been seeing it happen today. Now, lots been made about housing affordability and how we need to do this to reduce the cost of homes, and I suspect that government members are over-egging the impact of this legislation on housing affordability. There are just so many aspects to housing affordability, none of which the government are really doing anything about. The issue that my colleague Shane Jones raised, I think, is a very interesting one, and one which has been relatively unexplored in New Zealand, which is the cost of building materials relative to other countries, the cost of actually building the home. I do know that for example, before the Auckland Super City was formed, when you talk to developers up in Auckland about building houses, their one complaint was that all the different local authorities had different rules. And they said actually some were very, very good, some weren't so much. Some, if you had one development of, I'm not going to say which local authorities were which, but they said some, for example, if they had a development of 60 houses, the councils would put it all through in one process. Others would make them file for each individual house. There were different practices in different councils that in fact could have been dealt with without kind of completely removing levels of protection for consumers, the kind that we're seeing here. And the government really needs to play a much more active role in housing affordability across the board, rather than picking and choosing. And when they decide that it's useful for them to use housing affordability as an argument, use it, but then go and do other things which completely undermine what they're doing in housing affordability, like, for example, the fact that they've done nothing about the community housing sector losing charitable status under the Charities Act, something which is costing the Queenstown Lakes Community Housing Trust millions of dollars a year that they could be spending on building affordable houses. And the government sat on their hands and did nothing. Phil Heatley was told about it miles in advance of it happening. It went through the courts. They could have had a simple amendment to the Charities Act, which would have meant that those organisations would have been able to keep that money, which is earmarked for affordable housing, and spend it on affordable housing, and they've done absolutely nothing. So to say that this bill was going to be a panacea for affordable housing, when there are so many other things out there that they could be doing, properly investing in in community housing organisations, advertising the products that are available, unlike what they did with the Welcome Home Loans, which was refused to advertise them, shared equity, refused to...
I'm sorry to interrupt the honourable member. Her time has expired. I call Maggie Berry.
Thank you, Mr Speaker. I spoke at the second reading of the Building Amendment Act number